Breaking news. This is why SEC doesn't want William Hinman to talk about XRP lawsuit. If you were caught by the Ripple saga last June 25th, Ripple had subpoenaed a secret official, and we have no idea who it was. Therefore, I reviewed all the details that were available at the time. The identity of this SEC official would be made public just hours later, when I did not realize who he was. Welcome to Crypto Live. Please like the video and subscribe to our channel to stay updated on our upcoming videos about cryptocurrencies. There's no doubt that Ripple wanted to examine William Hinman under oath, and the revelations are astonishing. And this is the SEC director who received millions of dollars from his former law firm, so he left a law firm that worked at the SEC while he was also being paid by the SEC to do his job there. His former employer, a law firm, had important interests in Ethereum, so he decided that Bitcoin and Ethereum were both legal to move forward. In the end, he decided to return to his law firm after leaving the SEC. And if it doesn't sound incestuous and gross, I don't know what it is. Surely we all have made such guesses. Like, I don't know, I'm not claiming something illegal was done, but I'm saying this needs to be investigated, and certainly does not look good. Also, what are your thoughts? So for you to have a better understanding of what happened, here it is. In a motion filed last June 25th, the Securities and Exchange Commission sought to quash Ripple's deposition subpoena directed at former SEC Director William H. Hinman. Ripple Labs and its co-founders can't meet this high burden, the SEC argues, because the defendants have the burden of demonstrating exceptional circumstances justifying the deposition. According to the motion, the defendants seek testimony from Mr. Hinman regarding the SEC's internal views and policy decisions. The regulator argued against Hinman's deposition by stating that Hinman was of critical importance to the SEC's operations, that he didn't personally witness the facts at issue, and that defendants couldn't prove exceptional circumstances. It is my belief that any human could think unbiasedly and objectively about that. In fact, I do think that, and we have now found out that Ripple is seeking an oath from the guy. Hopefully, we'll find out what's happening, and this would be a huge blow. The fact is that, again, he gave Ethereum clearance after conferring with other SEC officials, and there is a lot that needs to be explained there. Moreover, if the SEC can keep William Hinman out of the picture, it makes sense that they don't care what he says. It's only natural that they want that because if Ripple gets to conduct an oath with them, it will not look good for them. It's probably all thanks to James Filan, who is an attorney who works with the XRP community. He is not with Ripple, he is not with the SEC, but he makes sure that all documents are up to date. As James Filan tweeted, the SEC filed a motion to quash the deposition of William Hinman, who previously ran the Division of Corporation Finance. Now, to the document, here's the starting sentence. Dear Judge Netburn, Plaintiffs' Securities and Exchange Commission respectfully requests a conference with the court to object to the deposition subpoena made to William H. Hinman. Ripple Labs, which is issued by the defendant to the SEC, was the former division of the Corporation Finance Director. It goes something like that. According to what I knew, if this is to be approved, the oath is to be administered on June 30th. Additionally, the SEC requests a writ of prohibition quashing the subpoena without prejudice pending the decision regarding Ripple's fair notice defense by Judge Torres. There has been written and video conferencing discussion on this issue. The parties are at a standstill. Therefore, you sit here wondering why the SEC dismisses a subpoena without any discrimination once it was served. As long as there is not a ruling on fair notice, you gotta wonder what the outcome will be, because if William Hinman appears, this will end up, in my opinion, strengthening Ripple's fair notice defense significantly would be a bad idea for the SEC. Besides the 5 commissioners, Director Hinman was the highest-ranking SEC official outside of them. Directors of the SEC's 6 divisions have greater responsibilities than any SEC of officers to depose a former high government official like Director Hinman. There's a burden of proof on defendants to show extraordinary circumstances justifying the deposition, so this is what somebody who doesn't live in the legal world can tell you subjectively. In terms of the way the SEC is arranged, I don't have a bunch of insight because I am not your typical layperson. Therefore, subjectively, I felt that Director Hinman was a director that looked more senior. It appears to be a higher-up individual, like the commissioner they cited in the document. In practice, it turns out that if you are in a high-ranking position, you have to meet a higher bar to demonstrate that you are aware of the exceptional circumstances. You can actually successfully subpoena and get somebody to testify under oath. And not just that, but if he's a high-ranking person, which I thought was the case, apparently it's more difficult to get them where you want them to be. In this case, Ripple is actually arguing that he is not sufficiently high in ranking, and I totally understand why Ripple would argue that way. However, I am just being honest here because I did think he was highly ranked. But again, it is just a subjective opinion and has no intrinsic value. If he is not the one, then he is not either way. I will say this though, regardless of his rank, he must answer for what he has done. I think it's disingenuous that only 2 out of over 8,000 cryptocurrencies benefited him, and that this is a matter of selective picking. XRP is directly affected, and then this needs to be addressed, since former officials' decisions remain under judicial review and a possibility of continuing involvement in lawsuits. Leaving office years after leaving public office serves as a significant deterrent to candidates for public office. I can understand that argument to a certain extent, but here's the problem. You understand that working at the top can make you a target for endless litigation and things of the sort. But here's the thing. I do get that, but at a minimum, it does look like he did something wrong, because it looks awfully bad. There may have been a time when something like this would have qualified for an exceptional circumstance. This is the time for litigation. So yeah, I understand that people could be forever litigated just for the nature of their positions, but it does appear that this is a bad situation. Ripple argues that they should be deposed in order to get testimony on how the SEC's internal views on certain legal issues are formulated in the process by which the SEC and its officials make policy decisions. To determine whether the SEC's position on a particular subject is represented by a public speech director, Hinman provided during his tenure. Asserting the SEC's deliberative process privilege over pre-decisional agencies, XRP was offered or sold as a security by gathering market participants' views on whether it was offered. Here you go. You see Ripple absolutely wants to ask William Hinman questions about XRP, since that is in line with what he has ruled about Ethereum. It is interesting how he talks about Ether specifically and compares it to XRP, and what Ripple has done and how they are treated differently. If the defendant's approach persists, high-level government officials will be deposed regarding every policy or law they discussed or consulted about. It was later the basis of a restraining order. So I read that, and I just said, they're thinking that won't happen to you. You won't be summoned for every little thing. You'll be called to speak for things. There was a little section titled, Director Hinman has no first-hand knowledge of the facts behind this action, but maybe that's just for when high-ranking officials do shady things, and this doesn't look good. Despite the fact that he acknowledged meeting and conferring with the Secret Service attorneys who would have dealt with the issue under penalty of perjury, Director Hinman did make a public speech concerning XRP last June 14, 2018, although he was not the director of the XRP division during his tenure as director. Based on his understanding of the specific facts and circumstances of Ether and the specific structure of the Ethereum blockchain at that time, he expresses his opinion that the offers and sales of the digital asset Ether at that time were not securities transactions. With Ethereum, they distinguished between the past and the present, but with XRP, they seem to not want to distinguish between the past and the present, and that's an illegal securities offering. But everything in the past and present with Ether is not an illegal securities offering. What in the ever-loving hell is that? And so look at this speech that they referenced again right there. There's a lot of relevance as to the legal status of XRP that Hinman needs to explain under oath, and that's exactly what we need right here. So let's see how things turn out here. But while reading this, I felt disgusted as they obviously know what they are doing is wrong and these people are absolutely unethical, uncaring asshats. And yet, they're getting away with it. The government is to blame, but my gosh, these are not good people. They are really poor attorneys. The job of those who are making crap is to see that they can trick anyone who is listening to what they're saying. It's so disingenuous to try to make them think that because that's what their job is, they're crap. These arguments are so illogical, and there is no way of knowing what constitutes a good legal argument because it depends on the individual. So, for an unbiased, logical person who hears facts, what would appear to be the logical argument? As for me, if you've been looking through them for more than half a year, it is obvious that the SEC is not acting in good faith. It appears they are not protecting investors, and I am disgusted by everyone else's position just as I am as well. I wonder if that is why there are so many XRP holders wishing to be represented. Are you able to comprehend how abnormal this is? You are hurting these people. Do something about it. Hinman's speech from 2018, along with specifics from the speech, along with how XRP is being treated, and what Hinman said during the speech as being important factors. As like me, we still believe in the potential of XRP. So we hope XRP will really prevail in this lawsuit. That's all for this video about crypto, and thank you for watching. If you would like to receive updates on the crypto market, make sure you click the subscribe and bell button.